With us this evening is Robert Tsai, a law professor at American University and authority on constitutional law, democratic theory, and U.S. political culture, and a few other things. He's written a very thoughtful book on how to deal with many of today's most difficult legal issues by essentially pursuing second-best solutions. The title of his book is Practical Equality, which in itself is an intriguing juxtaposition of words pairing the idealistic equality with the more pragmatic or grounded practical equality. That tempering of the ideal with the real reflects the crux of Robert's argument, which is basically this, that at a time when serious systemic inequalities persist in American society and continue to face legal challenges, whether involving voting restrictions, gender discrimination, racial profiling, xenophobia, and other wrongs, we should recognize that going for absolute equality may not be always the best strategy. While it would be great if all minorities and women and immigrants and others enjoyed the equality promised by the U.S. Constitution, courts do tend to shy away in many instances from sweeping rulings for a number of reasons. It may be their aversion to getting in the middle of big political fights, or appearing to overreach, or inciting popular opposition to the judicial system. Whatever the reason, Robert contends that in the face of such judicial caution and reluctance, a wiser, more promising approach by those seeking greater justice would be to base challenges on more limited and focused legal theories, what Robert calls substituting the idea of equality with the next best thing. Now, some of these next best concepts include fair play, the rule of reason, no cruelty, and free speech. Robert devotes a chapter to each of these and illustrates his argument with examples that touch on a range of past and present controversies, which you'll be hearing about in a minute. I'll add that while Robert makes a persuasive case for pragmatism, he also writes with quite evident passion about the moral imperative to combat inequality and not allow its disparities to fester. After law school and 2 clerkships for federal judges, Robert spent a while as a civil rights lawyer in Georgia. That time in the South, he says, working with students, clergy, protesters, prisoners, and homeless left a lasting impression on him. He went on to teach at the University of Oregon Law School before joining the faculty at American University just over a decade ago. Now, we're also privileged this evening to have Adam Liptak here to be in conversation with Robert. All of you who read the New York Times will recognize Adam as the paper's Supreme Court correspondent, a post he's held for 11 years. Adam himself practiced law for 14 years before joining the Times in 2002. So, ladies and gentlemen, please join me in welcoming both Robert and Adam.
Hello. So we're here to celebrate and explore what you've heard is a very interesting, provocative book, and I want to ask Robert to help set the groundwork a little bit and unpack some of the concepts we've heard about. Maybe the easiest way into it, Robert, is to ask this question. There's equality and there's practical equality. What's the difference?
That's a great question. And first of all, I want to thank everybody for coming to this event. It's been a real dream of mine to be able to write a book that's even worthy of being kept on the shelves here. Politics and Prose, an important independent bookstore, is really a national treasure. And so I want to thank all of you for being here. I want to thank the bookstore for having me, and also I want to thank Adam Liptak for being my conversation partner. So what's the difference between equality and practical equality? I think that what I would say is that equality is primarily a moral idea. It's a moral objective. that all of us mostly believe in. And that idea, of course, of equality is that people, as a moral matter, ought to be treated the same as much as possible. And we've got lots of places in the law, in our political texts, where we say exactly that in very strong, vibrant language. And most of the time, when we think about doing the work of equality, we think of it in those terms of trying to pursue those absolute moral truths to the best that we can. But it turns out that we have a really hard time doing the work of equality in practice, right? That we run into a number of roadblocks. We sometimes worry about the consequences of embracing someone's claim of equality, whether it's someone's claim to enjoy, if you're in a same-sex if you're a same-sex couple, whether allowing that couple to enjoy the fruits of marriage, that somehow that might change your notion of marriage. You might worry about some sort of political backlash. This is something that some institutions and some elected officials also worry about. And so for a lot of these practical reasons, we often in reality resist embracing the moral claim. And so I guess the idea of practical equality is that we have to think hard about all of the practical reasons why everyday people seem to resist the idea of equality. And if this is right, then what we ought to do is we ought to think hard about all of these other kinds of arguments and strategies that might also be effective in ameliorating some of the actual tangible forms of inequity that people are suffering every day, right? Whether they're migrants or they are people of color, there are lots of other ways that we can also reduce some of the injuries that these populations face.
So let me test one part of that. Is it your perspective that, and we're mostly talking about courts here, but people have a role to play in their thinking too. Is it your perspective that it's always a second best solution not to go straight to the equality argument? That a court confronted by a question of inequality the better route should be to rule on equality grounds?
Yeah, I do think that much of the time where people have really come forward with a very plausible, very strong equality argument, that we really need to take that seriously, right? And one of the things I do in the book is to plop readers right away into that weekend when President Trump's Muslim travel ban was implemented. And if you remember that weekend, it was incredibly chaotic. And I want the readers to remember that weekend for a couple of reasons. One, I want people to remember all of the hardships that people actually faced, and that they faced them disproportionately, right? It's not all travelers, but only those travelers that were expected to be coming from Muslim countries who indeed were mostly Muslim. The other reason why I wanted to plop readers into that weekend is that there was an upside to this, which is that if you remember that weekend, all kinds of people came out of the woodwork, right? We had lawyers, we had students, we had elected officials who wanted to even get in on the act, and they all descended on these airports to try to help figure out what was going on and to do some of the work that I call the work of practical equality. And so to me, the upside of that weekend is that this was a shining example of how hard it is, but also how important it is for everybody to get involved, both activists and lawyers, to do this work.
What do you think of the arguments, though, say that, as you know, right after Brown v. Board of Education, the Supreme Court considered whether to hear a case on bans on interracial marriage? The fight for same-sex equality went up through the court system, and the court initially ducked it. Even Justice Ruth Bader Ginsburg thinks the court might have moved too quickly on abortion rights in Roe against Wade. Is there ever a point at which courts should take the public's temperature in deciding whether the public is ready for an equality decision?
Yeah, that's a great description of how I think that courts are actually operating in real life. That all of us may be pressing these kinds of claims, these equality claims, these liberty claims, but in fact, courts are really populated by human beings like the rest of us, and they worry about the consequences of embracing these kinds of arguments. And one of the things that courts in particular and the Supreme Court especially is worried about, is a kind of political backlash that can come from kind of being kind of too far out ahead of where the people are culturally or politically. And as Adam pointed out, this is exactly what they feared when it came to integration of the schools. It was also what they feared, and turned out rightly so, at least for a period of time, when it came to same-sex marriage. Because does anyone remember the first court to say that as a matter of equality, same-sex couples ought to be entitled to the fruits of marriage? Which state court was that? Does anyone remember? I heard Hawaii. That was the right answer. So, what happened? What happened after Hawaii? And the Hawaii Supreme Court issued this ringing endorsement of equality in that case, was that the people of the state rose up and immediately enacted a state constitutional amendment to wipe out that decision. And then for a period of time, this was the danger in state after state, right? That marriage advocates really had to face the likelihood that any gains in terms of gay rights would be wiped out by voters. And so courts in those states, as well as I think the Supreme Court of the United States, watching what was going on, was worried about some of these practical consequences of equality that I talked about. So I do think that courts do pay attention to these kinds of things. They can't but help to do that. Mm-hmm. And sometimes when we understand that they worry about these things, occasionally what we can do is we can sort of change the conversation. So once in a while, if what we think is going on is that a court or an elected official, someone in a position of authority, is overly concerned with the consequences of equality, changing the conversation to a different kind of an argument might actually do some good. And some of the arguments I talk about in the book are fairness arguments, are the need to avoid cruelty. I talk about reason or empiricism. We have a real problem with some elected officials and occasionally some judges who don't think facts matter, right? We've heard this over and over. And this chapter is all about that, right? That there is a deep connection between empirical truth and avoiding bias and discrimination. And that if you don't care about the truth, then what you're going to be tolerating, among other things, is more discrimination.
So I want to bear down on some of those strategies, some of those second best solutions. But I want to ask you first a larger question. I think a premise of the book is that equality ought always be our overriding concern. And I just want to ask you, are there ever situations in which equality is in tension with other values, and we may have to take account of both?
Yeah, I think there are. The book is about equality, and I do think that's because that most of us accept that equality is a sort of central organizing value for all political communities, but especially for our own. And that's why equality is always sort of kind of hovering in the picture. But you're absolutely right that we have to make hard choices. That's also the other aspect of practical equality, is that sometimes the values of equality will be in tension with other kinds of values. Sometimes they'll be in tension with things like speech values. Sometimes they'll be in tension with religious freedom values, right? So the book isn't going to always tell us where to draw the lines, but it is going to force us, I hope, to confront just how tricky these questions are.
The other sense I got in reading the book are there two ways to think about these backup strategies. One is that they're second best solutions, but they're still solutions. The other is that they may be a little cynical and a little lawyerly, that you want to get from point A to point B, you can't get there directly, and you're going to be clever. What's your reaction to that critique?
I think that as a lawyer, as an activist, as someone who cares about equality, you're going to want to get there in whatever way you can. Mm-hmm. And I think that for the populations that are most vulnerable, the populations I talk about, whether they're migrants, whether they're people who have been adjudicated of a felony. One of the chapters I talk about is felon disenfranchisement, and the idea that we often accept, which is that people who commit crimes are categorically different from the rest of us, and therefore you can do all kinds of terrible things to them, including taking away their voting rights forever. Right? This is one of the things that's finally a question that we're sort of thinking through. But so I think that for these populations, whether you're homeless, whether you're a convicted person, whether you're a migrant, it really doesn't matter to you which of these arguments is going to work. What matters to you are the sort of the tangible effects of embracing one of these arguments, right? That the burden that you are experiencing, the Muslim traveler, right? The burden that you're experiencing will somehow be lifted.
So the first of the four strategies you call fair play, which is a good English concept, and lawyers might call it due process. And about that, you say that it can be valuable because it's less morally judgmental than an equality-based argument. Because I think you would say that some equality-based arguments, when you rule against somebody, they may think they're being insulted. They may think, wait, I'm against same-sex marriage and I lose. Are you calling me a bigot? Whereas your fair play arguments don't have that freight.
Yes, I think that's right. That's one of the sort of comparative advantages of something like a fairness argument is if you're in a heated argument with somebody over the notion of equality, there are a couple of reasons why, right? One is that there's a kind of structure to the way these kinds of conversations tend to. There's a structure of the arguments. There's a kind of a pattern that these kinds of arguments tend to follow, and what I say about equality arguments is that they tend to fall along this path, right? That we often get stuck over the question of who is deserving of equality. We assume that there's someone out there who doesn't deserve equality. So I already talked about felons, for example. What about someone who is accused of being a terrorist, right? What about someone who doesn't quite look like me? What about someone who doesn't share my values, right? So when we talk about equality, we often get stuck on this very question. And as you say, the other part of this is that when we say someone has violated someone's equality rights, that's a real morally judgmental thing that we're saying. And in the travel ban cases we've already talked about a little bit, I think this is one of the things that judges really get hung up on, is that if we strike the travel ban down on the reason that it violates religious freedom, aren't we saying that President Trump is a religious bigot? Now, it might be true that many of us think that already, all right? But for the Supreme Court of the United States to say that the president is a bigot is also to say, or at least strongly suggest, that millions of people who voted for him might also be bigots. And I think that this is one of the things that is subtly causing people, and including the Supreme Court of the United States, to not want to confront this question very seriously. And indeed, they end up ducking this, right? So what about fairness? So I think fairness actually can change the conversation, because it's not that fairness questions are non-judgmental. They're still judgmental, but they're judgmental about different things, right? They're not as judgmental about the who. They're more judgmental about policies, about practices, about institutions, right? This institution is not fair. That institution's not fair. Let me give you an example. In the book, I tell a story, and it's a story about a real case that is set in 1930s Jim Crow South. And it involves a case called Brown versus Mississippi, or what we might consider the forgotten Brown case, right? Some civil rights lawyers know Brown very well, but most people don't know this case. And what happened was there was a white planter who was found dead in his home, and suspicion immediately fell on 3 or 4 people who lived in the area, and they were all African American. And what happened during the investigation was that the sheriff and his deputies rounded up each of these individuals and beat them severely, including stringing one of them up a tree to try to get him to confess. And he did, and the posse did this, or the lynch mob did this more than once, right? And he insisted he was innocent, and these practices continued. Well, eventually, of course, the beatings went on so long that they, in fact, made confessions, and who wouldn't, right, to get the beatings to stop. And they were prosecuted, and they were given the death sentences, all of them. And when they challenged these death sentences, it was in a period of time in which arguments about equality would have had a really hard time prevailing in the courts. And one of those reasons is because of a concern that if we take equality arguments too far, in the criminal justice system, right? That we might change the criminal justice system too much. That this is one of the practical obstacles to equality in the criminal justice system. And what the Mississippi Supreme Court did in this case was to simply say, we don't see any problem here, right? As long as the procedures in court were fine, then we don't really care how that evidence was got. That decision was a travesty. And when that was appealed to the United States Supreme Court, I say that the Supreme Court got it right. They sensed that there was an equality problem here, that the methods that were used against these poor suspects would not have been used against anybody else, right? They were not the kinds of things they did to white suspects, for example. And they talked about what was at stake in clearly race-based terms. They really saw that this was a case of unequal justice, but they simply couldn't say that at the time. All of these concerns about embracing equality too far at that time in that system, I think, prevented them from doing it. So what did they do? The good news is I think that they did exactly what I suggest in the book, is that I treat this as an example of the Supreme Court trying to find some way to do practical equality. They embraced the fairness argument, and they said, okay, well, we're not going to worry at the moment about trying to judge these individuals of committing a moral wrong in a deep way, but we are going to say that this institution was, that this process was flawed from beginning to end, and that these individuals were entitled to be treated fairly throughout the court system and to rely on confessions that were gotten through beatings was fundamentally unfair. And so from my perspective, this was an example of doing the work of equality in a slightly different way.
So does it do the same work? Because the Supreme Court, as you know, Robert, does two things. It resolves particular disputes, and it announces broad legal principles that will apply in lots of cases. And had the court ruled on equality grounds, we definitely have the broad legal principle. I don't know that this kind of decision on fairness gets you there.
I think that it doesn't do exactly the same kind of work. It certainly didn't say these sheriffs are morally blameworthy in a deep way and we need to cast them out of the community. That was going to have to be done by somebody else. On the other hand, if we had insisted, or if somebody had insisted that they do it overtly through the Equal Protection Clause, let's say, they might not have been able to get to 5 votes, right, to do it that way. And to me, that's a serious problem, because one of the things I talk about in the book is that we have to avoid what I call tragic precedents, because there's fighting hard and there's fighting in a way that leads to a horrible result that ends up demoralizing activists, that ends up creating kind of monuments to inequality that can take generations to uproot. And we can think of cases like Korematsu, we can think of cases like Plessy versus Ferguson as really good examples of this. But one of the things that I think we have to keep in mind as we fight for equality is how do we fight hard, but without kind of falling into that trap where we're sort of partly responsible for creating a terrible precedent like that.
Do you think your book may be particularly timely in the current environment where the Supreme Court has just lately veered to the right and will not be, I would say, a particularly hospitable forum for lots of equality arguments?
I think that's a kind way of putting it, Adam. I actually would put, I might put it a little bit darker, that I think that, I mean, if you're a progressive, I think you look at the Supreme Court, and the Supreme Court's probably lost for a generation or more, right? In the sense that the Supreme Court can't be expected to be a predictable ally for a whole number of progressive causes, whether that's the rights of transgender people or expanding the right of sex equality in other ways. I think it's going to be really hard to expect the Supreme Court to do that in the future. So, but there's good news here. I think the good news is, A, we don't always have to rely on the Supreme Court. We can rely on other courts. There's a lot of really great work that state Supreme Courts are doing, and this is a great opportunity to make both very bold equality arguments, right, to those justices in those state courts, as well as all the other arguments I talk about, fairness, avoiding cruelty, and so forth. And so there's those opportunities kind of in terms of litigation, but there's also opportunities to make those arguments in states and local communities to try to prevent those policies from being enacted in the first place,
Mhm.
right? There's nothing that prevents us from making these kinds of arguments to other people, to mayors, to governors, to attorney generals. And as I like to tell my students, right, in some of these places where you're sort of the most demoralized, you know, you just have to win a couple of key offices, right? Win the governorship or win the office of the attorney general. Those two positions probably have more power than any other position to block at least the worst kinds of things that can happen.
I think I want to skip over lightly two additional backup strategies. You mentioned them in passing. Rationality, which is to say, courts can look at laws and practices and say this just doesn't make sense, and that's a route that's available. Uh, Barring cruelty, as the Eighth Amendment does and as normal moral human practice does. So those are two other backup strategies. But I'm particularly interested in free speech. My background is in free speech. And there, although you say most of these backup strategies are interlocking with equality, they're moving in the same direction. I think in speech, and you've already touched on this, there may be some tension, right? So consider hate speech. Hate speech is anathema to equality. And yet, under the U.S. Constitution, we protect it. How do you reconcile these things, and which side do you come down on?
Yeah, that's a great question because it's a tough question, and it's a tough question because although in the United States we've taken one answer, which is we have a very expansive understanding of free speech, we protect individuals' ability to espouse all kinds of hateful things up until the point that they cross a line, right? That they're actually exhorting some sort of law breaking, and that's pretty expansionist, right? In terms of protecting free speech. When we look at what other countries do, they've looked at what we do and think we're nuts, and they've explicitly repudiated what we do. So it's not as though the choice that we've made as Americans is absolutely the correct choice under all circumstances. Where do I come down on this? I think that is a really good example where speech can be understood to be in deep tension with equality, right? Because a lot of the things that lead to deep forms of inequality rely on the horrible sort of speech that is allowed to be expressed, right? That's how these ideas are communicated, and then kind of find their way into the minds and then the behavior of people. So there's no amount of denying that that's true. At the same time, we still, I think, we have a hopeful view in embracing this idea of free speech, which is that even though we protect the right of people to espouse these horrible things, we don't think that listeners are robots, right? We accept that it's possible. We hope people will hear something that's crazy and racist and bigoted and choose to say instead, "You're racist. You're bigoted. I don't agree with what you're saying." Um, and and to me, this hopefulness that goes along with this desire to sort of defend the ability of the dignity of the individual in expressing their view, whatever that view is, right, is doing, in this broader sense, some of the work of equality. But as you say, it's not an easy question.
And do you have some hesitation? So these doctrines we've been talking about were built in the 60s and 70s in a different era.
Mm.
Uh, in the internet era, and in the Trump era, and in the Charlottesville era, do we need to rethink any of this?
I think that there are ways to rethink that question in terms of perhaps what the state can do in terms of perhaps monitoring groups that because of their past practices merit being watched. I think that in Charlottesville, for example, there are things that the University of Virginia has done, that the local community has done in the wake of what happened that are perfectly legitimate. For example, if you're a group that has crossed the line and has violated the law while you're expressing your free speech values, it could be that you can get an order that prohibits you from coming back and doing that same thing once again. And that's a strategy that has been pursued, I think, quite effectively. So in a way, then, we're not really punishing somebody for their speech. We're punishing them for their law breaking or their rule breaking after the fact, and we're preventing that same rule breaking in the future.
I've got a couple more questions, but I know you guys are going to have lots of questions for Robert. So whenever you feel like it, you can line up at that microphone. So I want to ask about another situation in which two sets of values may be in tension. You all know the Masterpiece Cake Shop case, in which a Christian baker in Colorado refused to make a custom cake for a same-sex marriage, saying that would violate his religious principles. What's the right way to think about that tension? Certainly the equality value is easy to see, that people walk into a bakery and would like to get served and don't like being told that they're not welcome there because they're gay. But there are lots of people who think the religious liberty value on the other side is meaningful too.
Yeah, I think what I would say about that is that while that situation is often described as one where liberty is pitted against equality, it's actually more complicated than that, right? That let's start with the couple who's getting married and wants to get this cake, right? It's very important to them. It's also very important that they're treated equally like other customers. There's equality on that side. But there's also, in some people's minds, speech. There's association. They believe that they have the ability to go out, express themselves, who they are. That this is also part of the expression of their identity. Not everybody sees it that way. Now the courts also see it that way, but I think lots of regular people and some academics see it that way. And on the other side, what's often described merely as a liberty situation also has equality, because the religious objector there, right, isn't just objecting on his or her behalf. He's also objecting on behalf of a community that disagrees. And so, to the extent that an individual right of conscience, let's say, or a right of religion is respected, and it's possible that entire groups' religious beliefs are also deemed kind of worthy of respect. Okay, so I think the takeaway here is that you've got liberty and equality on both sides of it. Now, none of this tells us exactly where to draw the line. Where I personally would prefer to draw the line is where it respects the ability of local communities, let's say living in Colorado, to decide that equality is a very important value for this community, right? And to enact laws like public accommodations laws, and that is given a kind of a primary emphasis and respect. And then from there, we ask ourselves, is there a way to give someone who is an objector the ability to object, but without damaging that equality value? And so there might be a limited way to do that, but if we think there isn't, then my own view is that the equality value should be given the most respect.
So the book wasn't out yet, so Justice Kennedy cannot have read it. But
You can read it now.
I bet he has by now, but it wasn't out then. But in a way, he employed one of your strategies, but maybe not in the direction you would have employed it, because he went to the fair play idea. He didn't reach the equality question. He makes a fair play point and says one of the lower tribunals had not given the baker a fair shake, therefore he wins.
Yeah, that's a great example. So that just teaches us that there's no magical formula here, right? That if you make one of these other arguments, or even if you make the full-throated equality argument, there's no guarantee that anyone is going to agree with us. All we can do is do the best we can and use as many tools as we can possibly come up with in order to attack equality in all these different ways. So if there's one message from the book, it's that.
Let's turn to some audience questions.
Very interesting argument. So I have a two-pronged question. One part is, do you engage feminist theory in the book, or could you anticipate what your rebuttal would be to the kind of obvious feminist critique that equality, political equality, is the project? And if you're fighting this massive historical system of subjugation, if you're trying to bat it down in other ways, it's kind of this hydra-headed monster, and you're always going to be fighting it in one way or another. / what do you think of intermediate scrutiny under the Equal Protection Clause, and is that a good second best to an actual equal rights amendment, or is there value in pursuing that amendment as activists are doing now?
Boy, tough questions out of the gate. Woo. Okay, maybe I'll take the second one first. I'm pro ERA. I think that the movement to get the original ERA enacted, even though we've got this deadline that we got to deal with, right? Is good. That it adds something, to have something specific and broader about the importance of sex equality can be important in any number of ways. I've got a piece that's going to come out in Boston Globe in the next week or so, which talks a little bit about this, and I urge states that haven't done this to do it, and even to if they don't have an explicit sex equality provision in their state constitutions, that this is a place where activism would be very valuable. And well, what do you get out of it? Well, one thing you can get out of it is it could protect reproductive rights more powerfully. The other thing you can get out of it is that the way that courts see issues raised by transgendered people would be taken more seriously if we had something like that. And that's just the tip of the iceberg. So in terms of ERA, I'm a huge proponent of doing that as much as possible. Now, your first question is more of a it's sort of like a strategy question, right? So, and it's one that activists, friends of equality, are often face, and that's true today, and it's true back when we were talking about abolitionists trying to decide what's the best way of taking down slavery, right, and help enslaved populations, and that is like, if we choose this strategy, if we make these investments over here, we won't have quite as many resources for these other kinds of arguments. And are we, right, siphoning these necessary resources away from these sort of the direct attack, let's say, right, on the kinds of inequality or misogyny, whatever it is that you're going after? And I just think that there's no way to get away from that tension, right? That these difficult questions of where do we invest resources and which strategies do we pursue first and which are the backup strategies are always going to be with us. From my mind, if you care about equality, the moral argument about equality is always going to be your lead argument. But what this book is arguing is that we also got to think about the backup arguments, and that there'll be these moments where we can't convince somebody to change philosophically. Right? And actually, there's some science behind this, that if the goal is to change people's minds in this sort of fundamental philosophical way, that there are lots of reasons why that project will never happen, or it will take a long time. This is where I am. Let's just say it's going to take a long time, right? And so we have to see that arguments about equality in this deep moral sense are long-term conversations. So same-sex equality, same-sex marriage was an example of this. But luckily, we got there with that one, right? But along the way, we could do other kinds of things to reduce some of the harms that certain populations face. And if we can do that, then we ought to be doing both things simultaneously.
Thank you.
Thank you.
So I don't be shy. I have questions, but yours will be better.
Maybe. So, Doc, I have a two-pronged question.
Lots of two-pronged questions tonight.
So some have argued that the founding founders did not really trust all the citizens. So our democracy is not a pure democracy, it's a representative republic. So we have some representatives, we have regular elections, kind of like a stopgap if the citizens are acting a little bit too crazy. All right, so if that is the case, then how do you then reconcile circumstances where, so for example, we got past slavery and the slaves were freed, but then after enslavement, states instituted laws that if you jaywalk, then we're going to create this fine that you never can pay back, so you were an indentured servant for the rest of your life. So how do you then reconcile that maybe we have equality and we trust the American people, but at the same time, the founders didn't fully trust us? My second prong question is, where does unconscious bias play into this role of equality? You know, sometimes I was heading from the gym today, but I decided to get out my gym clothes and put on my little jacket because I was going to ask you a question. And I wanted to look credible.
You look great, by the way.
So thank you. All right, so, but sometimes unconscious bias is, if I'm 6 feet, 225 pounds, if I'm walking up on you, you know, you might have a unconscious bias. So how do we reconcile unconscious biases with equality?
Yeah, those are both great questions. Again, maybe I'll take the last one first. I do think there's a deep connection between unconscious bias and at least discrimination, right? That the attitudes that people have that they don't always fully understand that they have, they don't maybe interrogate, can lead them to behave in ways such as treating certain kinds of people differently, right? There is a little bit of recognition of this, even though there's resistance on the part of a lot of judges to use the term unconscious bias. There's a lot. Even the Supreme Court of the United States has talked about stereotypes, right? Sex-based stereotypes, gender-based stereotypes, racial stereotypes, and that they have recognized that there's a connection between kind of tolerating stereotypes and the kind of bias that can happen. And in the book, I talk about a few of these examples. I think that this is an area where you got to have more than one strategy, right? That just making us like a straight ahead moral argument about equality, about who deserves equality, isn't going to always get us to kind of dealing with that problem. One of the things that I think can is to demand that we interrogate the factual basis for certain kinds of claims, like that someone who is a member of a group poses a threat. So the travel ban we already sort of mentioned, right? The deeper claim there is that if you are Muslim, if you come from a Muslim country, you are in a group that is inherently threatening. This is the same kind of argument that was made during World War II as it relates to the internment of Japanese Americans, that because these Japanese people don't look like us, they have these strange, cultural practices, and wow, they even send their kids to foreign language schools, right? That they're somehow suspicious, right? They're deserving of differential treatment because they're scary. So this is kind of an example of, I think, what you're talking about. And one of the solutions here, or one of the things that can work maybe even better sometimes than direct arguments about equality, is demanding more about the facts, right? Show us more about what it is that somebody has done or some group has done that really lines up with a realistic projection of a forward-looking threat. And if you can't do that, then you're probably relying on stereotype or unconscious bias, as you say. Now, the first part of your question is a harder philosophical question to answer. I think you're right that our Constitution was founded through a kind of mixture, kind of a hodgepodge of ideas, right? There's kind of a deep commitment at the beginning to what you called Republican values, right? The notion of that what we need to do is kind of inculcate civic virtue among people, but also, as you suggested, a real fear and skepticism of democracy. They thought that too much power in the hands of everyday people would lead to the downfall of the United States, just like it has in every other society, right, that tried democracy. So you're absolutely right that they designed these institutions in a way that expressed that kind of a fear. I think we're in a very different place in lots of ways. We're in a place today where we embrace more broadly notions of democracy, one person, one vote. Even as we're hanging on to some of these relics, like the Electoral College, right, that reflect some of these things that you have described. Now, I don't have a real answer here. I think that we are just sort of trying to do our best, embracing this sort of newer belief in democracy. At the same time, we're sort of you're trying to figure out what to do with these institutions that are hanging around. So,
Well, I'm gonna buy your book anyway.
I thank you for that.
My question is simply one of clarification. I didn't really, I didn't really understand the rationale in your point that in the case of the Jim Crow South 1930s Supreme Court decision, where those that were concerned about equality under the law for the accused, because they had their confessions beaten out of them, that the better strategy was to go to fairness. It seems like both fairness and equality under the law would sort of rely on the same idea that African Americans should be treated fairly under the law, and they should be treated equally under the law. I don't see why the one was a better strategy than the other. You mentioned that the equality was that the justices were a little more sensitive to the whole, the strength, the importance, overriding importance of equality. Is that the only
Yeah. So
reason?
I think I'm glad you asked this question so that I can kind of push a little deeper. And there's more in the book about this, but I think the concern that the justices had, and lots of people have, and even today, a lot of judges have, about extending the notion of equality in certain contexts, like the criminal justice system, is that they worry that it's going to change, for example, or alter someone's institutional prerogative. One example would be, in the case that we're talking about, the prerogative of investigators to use whatever techniques, right, that they can, that are presumably lawful, right, to investigate. The prerogative of the prosecutor to make discretionary decisions about who to charge and what to charge. If we start to say that equality is an idea that can kind of come into this space, into these institutions, and constrain what investigators do and what prosecutors do, I think that this is where the judges have historically been very, very sensitive about doing that for this very reason. Now, how is that different from fairness? I think you're totally right that from the perspective of many of us, they sound a lot the same. And certainly from the perspective of the defendants, the defendant wouldn't care, right? Whether you take a fairness argument, equality argument, the death sentence is lifted. So, and that's the perspective that I encourage from a sort of pragmatic sort of point of view. But I think we can't hide the fact that the way that we talk about equality raises these serious and deep concerns about changing the prosecutor's discretion or the role of investigators in a way that judges would never want to do if possible. There was one earlier case where the idea of equality was extended to the criminal justice system in the late 19th century. And that was in a case where West Virginia had explicitly said by statute that black men could not serve on juries. And they did say, aha, right, equality comes into this situation to say that the state of Virginia can't do this. But the reason why they say that in that case is because they say something about jury service as a very special sort of social good, right? It's a mark of citizenship. It's something that we ought to be entitled to participate in if we are truly to be respected in a society. And you see how that's really different, right? That's the reason why the court ends up saying equality is important there. And they also don't worry about interfering with anybody's prerogative. So, but I think it's very different in the 1930s case, unfortunately.
Other questions? Let me, I'm sure you have them, but let me ask one in the meantime. So I've been trying to puzzle out how equality fits in with affirmative action. Not that long ago, Ivy League universities had quotas about how many Jews they let in. That presents an equality problem?
I think it does, yes.
Today, we're hearing from some Asian American students in lawsuits against Harvard and the University of North Carolina that something similar is going on with them. Do you have a take on what the right way to think about that is?
Yeah, this is another area where Americans are divided. But if you ask these institutions, whether they're colleges or they're high schools that have the ability to control the sort of demographics of their student body, they talk about the issues as one of educational experience, of giving kind of underrepresented groups opportunities that they might otherwise be prevented from, and they're trying to balance like a whole host of competing kind of values, if you will. And this is where the idea of diversity in that context has been treated as a serious value. That who we allow to go to school, especially in these state schools, is important for the rest of their lives, right? That it sets them up for their futures and their ability to pursue whatever sort of professional future that they want to have. And at the same time, as you say, we've got to worry about them not taking it too far. That they might be possibly discriminating, right, in a way, using these proxies. And so I think these cases will turn out only after we sort of look very carefully at the facts of the case, right? Because you can't really tell what's going on based on, I think, the coverage.
Yeah.
Yeah, my question is about how do you reconcile the super PACs donating endless money to campaigns, and how do you think that's going to play into our democracy when all these politicians are funded by big corporations, and these big corporations have a lot of power, and many would argue more power than the average citizen? How do you address that in your book, if you do?
Yeah, I don't directly address it, but I have some thoughts about that, and you know, I think my thoughts are that I think you're right. I think that you know, the problem with the Supreme Court's jurisprudence in terms of corporate speech and campaign speech. Well, first of all, it's a mess. But the most recent cases that defend in this sort of vigorous way corporations' sort of outsized political influence is a travesty. And the problem isn't that they rely on speech. It's that the court is hypocritical about it, right? They defend vigorously corporate speech, but they won't look as vigorously at the kinds of conditions that interfere with, you know, the rest of our ability to sort of have the same or equivalent impact on politics. And that's, to me, really the problem. So I don't have a problem with the court seeing that speech is involved in political advocacy. I think that basic idea has been useful to a lot of different groups in society. One of the groups that really needed it at a certain point in time was the NAACP, and I do talk about that. That there are some very important cases, and one of the stories I talk about is one where the Supreme Court has trouble deciding whether a state's restriction should be treated one as a violation of equality, and they can't get 5 votes. They can only come up with about 3.5, I think. Right? There's one justice who's waffling. I might as well tell you the story now. The story is that after the Supreme Court hands down Brown versus Board of Education, well, as we know, there's massive resistance. And in some states, including Virginia, what they do is they pass sort of creative laws to prevent lawyers from doing public interest work. And so what Virginia did was to pass a law to say that no lawyer in Virginia could solicit a client and kind of handle a case unless the organization itself had a financial interest in the outcome of the case. And of course, that would put all public interest litigation out of business because these people are volunteering their services for someone else, right? So a number of the justices, at least 3.5, thought this was a problem of equality, that what's going on is that Virginia was trying to frustrate Brown versus Board of Education. We can just extend the idea of equality just a little bit and say you're sort of trying to do this end run around equality. Well, the other justices would not have it. They said they're not mentioning race in the statute. And here's a practical consideration. We've long allowed Virginia as a state to regulate the practice of law. And so if we start sticking equality into this domain, then we're going to start creating all kinds of new constitutional rules that we don't want to have there. Okay, so what happens in this great story that I tell is that the Supreme Court ends up finding an argument that nobody argued, nobody briefed: free speech, and they said that the NAACP's right to free speech, a form of political advocacy through litigation, was violated. So to me, this is great, and it's an example where speech and equality lines up. I just think that the court has to be consistent about thinking along those lines.
I think we've got time for one more question.
Hey, Professor Tsai, how are you?
Great to see you.
In response to the new Criminal Justice Reform Act, which long-lasting implications do you see in regards to the new changes and also in steps towards achieving equality? And how's that reconciled with the current administration's view on criminal justice and the different direction it took compared to the last administration?
Yeah, there's a lot of interesting components to the criminal justice reform bill. I think what I'd rather sort of say, though, is that that's actually a really good example of certain kinds of elected officials deciding that equality was something that they should care about, that we ought to care about, and then finding ways to reach a consensus. Some people say compromise, but I don't like compromise because it sounds like through compromise that somehow what you're willing to take is half a loaf. And this book is decidedly against the idea that if you believe in equality, you should take half a loaf. Is that we should be more clever and find ways not to take half a loaf, right? And yet to find different ways to ameliorate the injuries. And so I think that from what I've seen from the criminal justice bill, there were people who cared about racial equality. I'll just mention Cory Booker, but he's not the only one. There are a lot of other people who worked on this legislation, and through a variety of different kinds of, I think, appeals to these different people, including some key Republicans, and I guess even Jared Kushner. Am I right about this? Yeah. So, right? I mean, he's the one who convinces his father-in-law to sign it and to take credit for it, and God bless him for that, right? So whatever arguments and variety of arguments were being made, and I heard some. It had an impact. And to me, so the whole process is a good example of this, right? But in terms of the actual prediction about what will have the most lasting impact, I'm not sure. Do you have any ideas about that?
Not right now, no.
All right.
So this was such a fascinating discussion, full of insights. Please express your admiration for Robert by clapping and by buying the book.
Thanks so much for coming out. And thank you, Adam.